Hello and good morning, everyone. Welcome to this virtual presentation, which talks about ESG considerations for investment firms. It's going to be presented by me, Stuart Holman, for the first part, and then my colleague, Carwyn for the second part. This presentation is being recorded, and there's the option to ask questions throughout the presentation. And we will try and answer the ones that we can in the time at the end. Any we can't get round to or need a bit more thought, we'll obviously get back to you separately. This is what we're going to be covering. The issue of climate change, regardless of where you stand on the issue, affects everyone. And we'll take a look at some of the big themes and follow it down to some of the individual regulatory applications that are just around the corner. So the ESG tectonic plates, as I've called them. As I said, the climate change issue affects everyone, from the most evangelical eco-activist to the most vociferous climate change denier. And of course, it's also not something that just affects the financial services market. So it affects everyone in every industry to a greater or lesser extent. Now, to some industries, it's a threat, for example, the oil industry. Others, it's an opportunity, and to some, it's the reason why they exist. So in an attempt to put some sort of structure to the big issues, the tectonic plates, as I've called them, I will talk about some of the key international policy drivers, then look at how these are connected to some of the key EU policy streams, and then look at some of the key UK initiatives and how they complement these international and EU initiatives, before handing over to my colleague Carwyn Evans, who will put the spotlight on one of the known knowns for UK regulated firms. So the world picture, starting with the old world, and where did it all start? Well, interestingly, the ancient Greeks postulated that cutting down trees could influence rainfall. And of course, it was the Industrial Revolution that was the first big step to where we are today. And early on during the Industrial Revolution, the injurious to health nature of many industrial processes was identified and understood. But it wasn't until the 1890s that scientists raised the thesis that an increase or a decrease in CO2 could trigger an increase or decrease in global temperatures. And so far as it appears from contemporary records, the most common reaction to that idea was that a warmer Earth was to be welcomed. It was in the 1930s that British engineer Guy Callender published research on the correlation between levels of CO2 in the atmosphere and increasing global temperatures. And over his lifetime, he saw the sort of accepted scientific thought shifting from skepticism to at least a certain degree of concern. Jumping forward in the interest of time, the starting point I have chosen, which of course is actually the culmination of 50 years of debate and action, is the UN resolution from September 2015, 71, Transforming the World, the 2030 Agenda for Sustainable Development. And we can already see that concerns about CO2 and climate change have morphed into an overall concern for sustainability. And one of the key characteristics of the climate change sustainability ESG debate is a question of definitions. What do we mean? The UN resolution focused on sustainability, but included in its 17 sustainable development goals are ideas straight out of the ESG agenda. For example, sustainable agriculture, sustainable management of water, sustainable energy, and sustainable economic growth. Next came the UN Paris Agreement in December 2015. Now, of course, everyone's heard of this, not least because of President Trump's repudiation. The Paris Agreement includes a commitment to align financial flows with a pathway towards low carbon and climate resilient development. And then the network of central banks and supervisors for greening the financial system, which was established in December 2017, was brought in to strengthen the global response to meet the goals of the Paris Agreement and to, on the one hand, enhance the management of climate risks in the financial system, and on the other hand, to mobilise capital towards green and low carbon investments. And it is this duality of the management of risk on the one hand and the doing of good on the other, which is at the heart of the ESG and sustainability story. And the network's first comprehensive report from April 2019 includes within it the statement that climate-related risks are a source of financial risk, and it is therefore, it falls squarely within the mandates of central banks and supervisors to ensure the financial system is resilient to these risks. As a CRO at a bank said to me recently, admittedly before COVID, he said, whatever I feel about climate change, managing climate-related risk is now a top priority. And then we have the FSB's Task Force on Climate-Related Financial Disclosures, the TCFD, with its 4 overarching disclosures on governance, strategy, risk management, and how they assess climate-related risks. And then its 11 supporting disclosures. And this focuses on the third of my tectonic plates, the disclosure plate. The idea is that investors will be able to make more sustainable investments, the do-good plate, and manage climate change risk, the second plate, if they are provided with more effective climate-related disclosures, the third plate. And finally, the IOSCO final report on sustainable finance made 10 recommendations to regulators in emerging markets for them to consider when issuing regulations on sustainable finance. And this recognises the world nature of the problem, and that we'll all need to work together if we're going to get to the end goal of sustainability. Having looked at the international dimension, moving slightly closer to home to look at the EU. And there are a number of strategy documents and regulations, and some of these will have effect in a post-Brexit Britain. Others, it's unclear at this stage what it will mean for UK regulatory policy. Starting with the Commission's high-level experts group, which was established in December 2016, and it was established to help in building the roadmap to sustainable finance. And the high-level experts group's final report in January 2018 supported many of the EU policy actions that I'm going to talk about. And the composition of the experts group recognised the plurality of expertise needed to make sensible policy decisions in this complex area. One of the policies the high-level experts group supported was the Commission's Action Plan for Sustainable Finance, which was published in March 2018. And it's interesting that this policy document proceeded on the basis that the scale of the sustainable finance challenge is beyond the capacity of the public sector alone, and that the private financial sector is essential to reaching this sustainability goal. The plan formed the roadmap for the measures that follow on taxonomy, on disclosure, on risk management. And it is this action plan that the UK has pledged to match the ambition of. The low carbon benchmarks regulation creates a new categories of benchmarks of low carbon and positive carbon impact. And that was put together because it was designed to remedy what was seen as a divergence of approach across the EU and to ensure a consistent approach to preventing illegitimate claims by benchmark administrators about the low carbon nature of their benchmarks. The Sustainable Disclosures Regulation from November 2019 is going to be the focus of my colleague Carwyn's presentation, but self-evidently it is addressing one of my 3 tectonic plates, the fact that disclosure as a weapon to support achieving sustainability. The European Green Deal from December 2019 aims to mobilise at least €1 trillion of investments toward a climate neutral, green, competitive and inclusive economy, all the while ensuring a just transition to a green economy. And this echoes some of the United Nations 17 Sustainable Development Goals. Not to be outdone, ESMA has got heavily involved and it issued its strategy on sustainable finance in February. And in it, ESMA identifies some of the key risks to sustainability as being ESG washing or greenwashing, mis-selling and misrepresentation, lack of transparency, and genuine confusion about what is sustainable. That's part of the reason for the existence of the high-level experts group. And it's to address this confusion that was the aim of the taxonomy regulation. Now, the EU's taxonomy regulation was finally enacted in July of this year, and it's an interesting piece of lawmaking. And for a regulation that's intention is to formally agree a set of definitions for what is sustainable, it proved to be a more politically charged process than you might have thought, particularly regarding the part to be played by nuclear power. Is it a hero or a villain? To simplify the regulation, the taxonomy regulation, it sets out that for something to be an environmentally sustainable economic activity, it will have to, 1, contribute to one or more of the environmental objectives, and I'll come on to what those in a moment. 2, do no significant harm to any of the environmental objectives. And 3, comply with minimum social and governance safeguards. The environmental objectives are climate change and mitigation and adaptation, sustainable use, protection of water and marine resources, the transition to a circular economy, pollution prevention, and protection and restoration of biodiversity and ecosystems. And again, these reflect many of the Sustainable Development Goals of the United Nations Resolution 71. And finally, on the EU side, the Commission published draft delegated acts to integrate sustainability into MiFID II, AIFMD and UCITS, amongst other directives, which my colleague Carwyn will touch upon. Though, of course, these are one of the areas where it remains unclear for UK regulated firms precisely how these changes might end up impacting them. As you can see, there are a number of UK initiatives at government and regulator level. And of these, one of the key elements is the UK government's commitment in the Green Finance Strategy to at least match the ambition of the 3 key objectives to the EU's Sustainable Finance Action Plan. These are to reorientate capital flows towards sustainable investment, that I've called the do good tectonic plate, to manage financial risks stemming from climate change, the risk management tectonic plate, and to increase transparency, the disclosure tectonic plate. And the UK has decided to onshore the low carbon benchmarks regulation, and as Carl will explain, the Sustainable Disclosures Regulation will form part of retained EU law after the end of the transition period. And among the FCA's own proposals is the proposal, picking up on the transparency point, that premium listed companies will have to adopt a comply or explain on their position on the TCFD's recommendations. And if these come into effect as planned, they will apply to accounting periods beginning on or after January the 1st, 2021. And of course, asset owners and asset managers have been working for the past year under their own comply or explain disclosure regime brought in under the Financial Reporting Council Stewardship Code 2021. Finally, for my part, the Climate Financial Risk Forum published its guide in June to help financial firms understand the risks and opportunities that arise from climate change. Once again, it focuses on risk management and scenario analysis, a risk plate, disclosures, and the opportunities that do good. Those are the 3 plates as I see it. And now I'm going to hand over to my colleague, Carwyn Evans, who will talk about the Sustainable Disclosures Regulation.
Thank you, Stuart. Okay, right, I've made a transition there, so hopefully technology has served me well. And you should be able to now see the Sustainable Disclosures Regulation slide up on the screen. Okay, so let's start with this. We'll just look in more detail at the SDR. We're going to look at an overview and then go into some definitions before getting into some of the compliance matters to consider. Now, regardless of individual views, and I've come across a lot of individual views over the past year or two in relation to ESG, these requirements are going to become a compliance matter. It's a hard fact. Now, as Stuart mentioned, the SDR came into force at the end of last year and retained under the Brexit legislation. Although there are, some vital elements that we're still not sure as to whether this is going to feed through. So the regulatory technical standards you see as part of your the typical EU regulation, and the implementing technical standards, they come into effect after the transition period. So it remains to be seen whether the UK will adopt. I mean, I think many commentators suggest that they will in most parts, but there might be amendments to them. The SDR applies effectively to firm and product level, and applies in the main from the 10th of March 2021, though there are some obligations commencing at the very beginning of 2022 and the very end of 2022. Well, what's the aim of the SDR? Similar to sanctions, really. It's trying to promote, force change for good. And the aim is essentially to impose rigorous, harmonized standards of disclosure and application of sustainability risk management across the industry. So trying to force that through in the name of environmental matters and society matters. The SRD applies to financial market participants and financial market advisors at a firm level, and these include, certainly from the FMP side, investment firms providing portfolio management, AIFMs, UCIT mancos, certain insurance and pension providers across Europe, among others. Financial advisors include investment firms, insurance firms, AIFMs that are providing investment advice on these relevant products. The application does vary, though, between the FMPs and FAs, depending on the nature of the service that they're offering. At a product level, it applies to AIFs and UCITS and portfolios managed under MiFID and insurance-based investment products as well. I want to have a look at some of the important definitions to bear in mind here. So the regulation itself has got an awful lot of them, but I just want to draw out three important here that don't tend to crop up in other European regulation that we're familiar with. So sustainability risk. This is an ESG event or a condition that, if it occurs, could cause actual or potential material negative impact on the overall value of an investment. So looking to eradicate, the short-termism that certain investment firms may take. Give you an example: real estate investments, for example. Investing in real estate that's been established alongside tidal rivers, without considering the impact, perhaps, of sea level rising and matters like that. Likewise, sustainability factors as well as a definition that defines environmental and social and employee matters, respect for human rights, anti-corruption, anti-bribery matters. Effectively, these are the factors to be considered under the definition of sustainability. Onto sustainable investment. This is effectively looking at an economic activity that positively contributes to an environmental objective or a social objective. So environmental objective could be, renewable energy investment, or investing to improve, the circular economy rather than linear economy. Or it could be things like, gender representation in governance arrangements, or pay gap equalization for gender matters. But Stuart mentioned this earlier under the taxonomy regulation. At the same time, whilst a firm is positively contributing to one of these objectives, they must ensure that they do no significant harm to other objectives as part of this. And Stuart mentioned, nuclear, the nuclear debate. There's elements that it's got a positive impact on certain objectives, but it could have a negative impact on other environmental or perhaps social objectives for those that live in the shadow of a nuclear facility. for example. And also as well, it forces the idea of pushing good governance practices through around these ESG matters facing firms. If we now look at the firm level disclosure obligation, so firms, both FMPs and FAs, they need to publish website disclosures. So that would include information about the firm's policies on integrating sustainability risks into their investment decisions. That's for the FMPs. And the same thing applies, but for investment advice. You know, how do advisors consider integrating sustainability risk into the advice and the advisory process that they bring to the market? Also as well, remuneration. Remuneration's been the cornerstone of a lot of regulatory change over the years. You know, if you link the actions that regulators and regulation requires to firms or individuals' remuneration policies, there's more likely for that to change. So it's the integration of sustainability risk that becomes an obligation under SDR. FMPs and FAs, they also must disclose in pre-contractual disclosures how sustainability risks are integrated in their investment decisions and investment advice. They also must share the outcomes of their assessment of the likely impacts of sustainability risks on the returns of financial products. Don't forget, it's not a kind of gung-ho, just go for one outcome, which is to make sure that ESG things matter. There's also an important impact about balancing the interest of investors and their needs and whether products are suitable for them as well along that journey. Where sustainability risks are not relevant, then firms will need to explain why. So, for example, a financial advisor needs to disclose how they take sustainability risks when they're selecting the financial products that they are presenting to end investors, for example. Disclosures incorporated in offering documents, information memorandums, prospectuses, KIDs, the types of product disclosure measures that are in place depending on the products concerned, and the relevant regulation that drive those disclosures. One thing that's worth checking, and it's guys worth taking a note of this because it's not written in the presentation itself, there's some really useful mock-ups of these disclosures available. There is a combined effort by ESMA, EBA and EIOPA, which sets out a number of mock-ups of how these disclosures could work. And from my point of view in advising firms on these kind of disclosures over the years, it's important to be able to see what what are these things meant to actually look like in practice. So you can see those mock-ups very clearly in that particular document. On to additional disclosures for FMPs. So FMPs must publish and maintain website statement on due diligence policies regarding the principal adverse impacts of the investment decisions taken on sustainability factors. Now, it's a mouthful. What does it actually mean? I mean, essentially it means that, and it's described in the recitals as meaning, you need to consider the impacts of investment decisions and the advice that could result in negative effects on sustainability factors. It needs to be a fundamental consideration, and disclose the policies that you have in place around the due diligence you undertake to ensure that. Okay. Now, again, for this particular page, it's important to remember that there's an element of proportionality applying here. So for smaller FMPs, and Stuart alluded to this earlier, there's a compliant or explain element to it. Now, the statements, these further statements that FMPs need to publish on their websites could include information around their policies on identifying and prioritizing principal adverse sustainability impacts and indicators, principal adverse sustainability impacts and any actions already taken or planned by the firm, shareholder engagement policies, how they adhere to responsible business codes of conduct, internationally recognized standards for due diligence and reporting, and where this is relevant, the degree of their alignment with objectives of the Paris Agreement. That's it for the firm level points I wanted to cover off briefly this morning. So on to the product level points now. So for all financial products, firms need to present a clear and reasoned explanation of whether and how a financial product considers principal adverse impacts on sustainability factors, or a statement from the S&P, the FMP that does not consider the impacts of the decisions on sustainability factors and the reason why. So again, it's this kind of comply or explain approach, which, you know, it's putting the ball firmly in the court of the market participants to demonstrate that they engage with ESG in a positive way, and they're thinking it through very clearly across the business. For financial products promoting environmental or social characteristics, explaining how the financial product actually meets those characteristics, and where there is perhaps an index has been designated as a reference benchmark on those particular products, information on how that index or indices are consistent with the characteristics of the product itself. And for products promoting sustainable investments, where again benchmarks have been referenced, information of how that index is aligned with the objective of those investments. So, you know, bear in mind when you look at these environmental or social investments, they typically have an environmental or social objective, an outcome to the investment. So it's important to be able to align those indexes where they're used with the objective. And if there is a difference between the objective and the referenced information in the index, then that is explained also. And where no index has been designated, an explanation of how the objective is actually being attained in absence of that index. Okay, these disclosures, though, they need to be made in pre-contractual disclosures as well as on the websites of the FMP in terms of they appear in the form of periodic reports. And just to close off, Stuart mentioned earlier, and this is where, you know, the plot always thickens, doesn't it? But nothing straightforward, especially with Brexit in consideration. So forthcoming ESG changes, you know, that impact things like MiFID and AIFMD and UCITS regulation, and because there are, you know, certain parts of the delegated acts that and the technical standards that are not factored in just yet, it remains to be seen how far the UK will go. Again, I mentioned earlier, there is market commentary that the UK will likely try to create a level playing field with the UK, but not to be too political. I'm not sure what the government will do about that. But just a brief summary here, just in preparation and understanding of what this impact could look like for these various existing regulations. So AFIMs and UCIT MANCOs, they need to consider sustainability risks, take them into account when complying with their, you know, governance and organisational arrangement requirements. Integrate ESG considerations into their organisational requirements, deploying senior management expertise and ownership to ensure the effective integration of sustainability risk management across these type of firms. Integrate and identify again sustainability risks in its conflict management framework. Consider the principal adverse effects of investment decisions on sustainability factors, and integrate sustainability risks into the investment due diligence process and risk management policy. So again, this is about pushing a top-down agenda, making sure that there's ownership and responsibility at the top of the business that drives that down, and, you know, takes clear ownership and makes procedures and appetites and processes that adopt these principles. And for MiFID investment firms, to take into account sustainability risks, again, when complying with the organisational requirements, and integrating sustainability risks into the risk management policies, carrying out of sustainability preferences of clients, and include them when they're selecting financial products. Again, this is the whole concept of suitability and linking other conduct and product matters into now another regulatory driving force, and incorporating sustainability factors in the product approval process. The whole product governance element needs to now consider, or will need to now consider, how sustainability matters have been considered into it, and as you know from product governance matters, it's not a case of doing it at the launch of the product. There's an ongoing process to ensure that the product is delivering what you expected it to do, not just in terms of its outcomes for the investor and returns and performance, so on. It's about, are the ESG impacts around those particular products, are they performing like you expected them to do? Considering this is a potentially changing landscape, that's something that's an important part of the product governance cycle. I mean, in reality, the majority of this has been factored in, but it does remain to see how far the UK will go in adopting all of the regulatory technical standards and the implementing technical standards that come through. I know that whilst they're quite wordy, they do serve a valuable process and source of information for firms like yourselves. So let's wait and see how that pans out. Okay, that brings us to the end of the presentation today. So let's see if there's any questions and answers. Bear with me while I navigate this. If anybody has any questions and answers specific to what myself and Stuart have just discussed now, then please feel free to get in touch either through the Q&A options you have in front of you today, or quite a few of you I think we know already. Feel free to send us an email asking us questions. Now we will share the presentation with yourselves after the event. So if there's anything that crops up from there, you have mine and Stuart's contact details. More than welcome to contact us and ask anything that you wish to do. Stuart, is there anything else that you'd like to add?
No, certainly not. I just want to say thank you to everyone for attending.
Thank you.
Have a good day, everybody.
All the best. Take care now. Bye-bye.